Attorney General.
Yep.
Thank you. Order. Statement. The Attorney General.
Mr. Speaker, it's very good of the Prime Minister to warm up for me today. Mr. Speaker, with your leave, I wish to make a statement to the House. I should make clear the context in which I consider that I am to do so today. My statement today is intended to inform the debate that is shortly to commence on the motion to approve the withdrawal agreement and the political declaration on the future relationship concluded with the European Union by my right honourable friend, the Prime Minister. It is important, Mr. Speaker, to understand how the law officers habitually give their advice, which may be a mixture of oral and written communications given at different times during fast-developing events. Ministers are advised by their own departmental lawyers, and the points that arise for consideration of the law officers are invariably limited to the relatively few of particular importance to the policy decision of the government. Therefore, my statement today is complemented by a detailed legal commentary provided for the purpose of the debate and published this morning, which analyses the effect of the agreement as a whole. That legal commentary has been produced with my oversight and approval, and I commend it to the House as both an accurate examination of the provisions of the agreement and a helpful exposition of some of the salient issues that arise from them. There is, of course, no want of other sources of helpful commentary available to the House. In making this statement in these unusual circumstances, and in answering any questions that honourable members may have, I consider that I have a solemn and constitutional duty to this House to advise it on these legal questions objectively and impartially, and to place such legal expertise as I have at its disposal. The historical precedents strongly support that view. The House may be sure that I shall discharge this duty with uncompromising and rigorous fidelity. If this agreement is to pass this House, as I strongly believe it should, I do not believe that it can or should pass under any misapprehension whatsoever as to the legal matters on which that judgment should be based. It is important to recall that the matters of law affecting the withdrawal agreement can only inform what is essentially a political decision that each of us must make. This is not a question of the lawfulness of the government's action, but of the prudence as a matter of policy and political judgment of entering into an international agreement on the terms proposed. In the time available to me, it is impossible to have covered each of the matters of law that might arise from 585 pages of complicated legal text. And no Attorney General, and certainly not this one, can instantly possess the answers to all of the pertinent questions that the skill and ingenuity of honourable members may devise. However, I am aware that there are certain parts of the agreement, the meaning of which attracts the close and keen interest of the House, and it is to some of these that I now turn. First, the Northern Ireland Protocol and some of the other provisions of the withdrawal agreement relevant to it. The protocol would come into force, if needed, on the conclusion of the implementation period on the 31st of December 2020, unless, pursuant to Article 132 of the agreement, both the UK and the EU agree to a single extension for a fixed time of up to 1 or 2 years. By Article 1, the protocol confirms that it would affect neither the constitutional status of Northern Ireland nor the principle of consent as set out in the Belfast or Good Friday Agreement. The statutory guarantee that a majority in Northern Ireland would be required to consent to a change in its constitutional status as part of the United Kingdom, and the associated amendment to the Irish Constitution to remove its previous territorial claim remain in place. Once in force, by Article 2.1 of the Protocol, the parties would be obliged in good faith to use their best endeavours to conclude, by the 31st of December 2020, an agreement that supersedes it. There is a separate but closely related duty on the parties under Article 184 to negotiate expeditiously and use best endeavours in good faith to conclude an agreement in line with the political declaration. Having regard to those obligations, by Article 1.4 of the Protocol, it is expressly agreed not to be intended to establish a permanent relationship, but to be temporary. That language reflects the fact that Article 50 of the Treaty on European Union does not provide a legal basis in Union law for permanent future arrangements with non-member states. If either party did not comply with its obligations of good faith, after the implementation period, it would be open to them to bring a complaint under the dispute settlement provisions set out in Articles 164 to 181 of the agreement. These include independent arbitration. Clear and convincing evidence would be required to establish a breach of that obligation. If the protocol were to come into force, it would continue to apply in international law unless and until it was superseded by the intended subsequent agreement which achieved the stated objectives of maintaining the necessary conditions for continued North-South cooperation, avoiding a hard border, and protecting the Belfast Agreement in all its dimensions. There is, therefore, no unilateral right for either party to terminate this arrangement. This means that if no superseding agreement can be reached within the implementation period, the protocol would be activated and in international law would subsist even if negotiations had broken down. How likely that is to happen is a political question, to which the answer will no doubt depend partly on the extent to which it is in either party's interests to remain indefinitely within its arrangements. Under the protocol, the UK would form with the EU a single customs territory for goods for fiscal or tariff purposes. Accordingly, Northern Ireland would form part of the same customs territory as Great Britain, with no tariffs, quotas or checks on rules of origin between Great Britain and Northern Ireland. However, Northern Ireland would additionally apply defined aspects of the EU's single market rules relating to the regulation and control of the supply of electricity on the island of Ireland, goods, including cross-border VAT rules, and the EU Customs Code. These rules would be enforced as they are now, including preliminary references from Northern Ireland courts to the Court of Justice of the European Union. By these means, the need for any hard border would be avoided, and goods originating in Northern Ireland would be entitled to free circulation throughout the EU single market. In all other aspects of its regulatory regime, Northern Ireland would follow the applicable UK legislation, save where these were devolved. Mr. Speaker, by Article 7, a Northern Ireland business would also enjoy the same free circulation of its goods throughout the United Kingdom, while its EU competitor, whether situated in the Republic of Ireland or elsewhere in the single market, would not. Mr. Speaker, I turn now to the role of union law and the CJEU under the withdrawal agreement and within the dispute settlement provisions. It is important to place these provisions in the context of the objectives of the agreement, which is the orderly exit of the UK from the EU for our citizens and businesses. To this end, following the implementation period, the agreement provides for the continued application of union law in defined and strictly limited respects where it is necessary or desirable for legal certainty to do so. Although we will legally leave the EU and cease to be a member state on March the 29th, 2019, Part 4 of the agreement provides for an implementation or transition period of 21 months, which is designed to enable our people and our businesses to adjust to the changes that are coming. During that implementation period, so as to give the time, predictability and continuity that is needed, it is provided that union law should continue to apply, and the laws, systems and institutions of the EU will have the same role and functions as before. But on the conclusion of this period, on the 31st of December 2020, that will come to an end. Thereafter, union law and the Court of Justice will possess a relevance in the United Kingdom only insofar as it is necessary in limited and specific areas for the winding down of the obligations of our relationship of 45 years. For example, the rights of our own citizens living in EU member states and of EU citizens in the United Kingdom are created and defined by union law. If they are to be preserved in equal measure and with the necessary consistency and certainty, it is inevitable that the mutually protected residence and social security rights of these particular groups of people must be continued to be defined by reference to that law. These rights are provided for in Part 2. Our citizens living in member states throughout the EU will continue, as is natural, to depend for their ultimate protection on the CJEU, while EU citizens living in the United Kingdom will look to the UK Independent Monitoring Authority set up under Article 159 and to the UK courts. But they will no longer be able, as now, to require our Supreme Court to refer a question of interpretation of their rights under union law to the CJEU, where the determination of such a question is necessary to resolve a dispute. Instead, pursuant to Article 158, the UK courts, for a fixed period of 8 years only, may refer to the CJEU a question of interpretation of Part 2 of the agreement in the interests of achieving consistency in the enforcement of the rights of citizens and while the new system is established. After that time, our courts will, pursuant to Article 4.5, continue to interpret concepts and provisions of union law in the areas in which the agreement applies it, as they always have, and to have due regard to relevant post-implementation case law where, for example, it may be required for the practical operation of the agreement, such as in regard to the coordination of social security rights for the protected EU and UK citizens. Part 3 deals with the lawful conclusion of judicial and administrative proceedings, transactions, processes and other matters that have arisen or commenced under union legal frameworks before the end of the implementation period, and to which union law and the role of institutions must continue to apply for their orderly disposition. It allows a 4-year limitation period on the power of the Commission to refer to the Court an alleged breach of an obligation incurred prior to the end of the implementation period. Part 5 deals with our agreed financial obligations. It provides under Article 160 for union law and the jurisdiction of the Court to apply beyond the implementation period only for the time and purpose of closing out the UK's financial obligations and entitlements incurred under union law, again prior to the end of that period. All of these are inherently time-limited functions, and once they are at an end, the Court will have no jurisdiction in relation to disputes involving citizens and businesses in the United Kingdom. A dispute between the EU and the UK about the systemic operation or interpretation of the agreement may be referred by either side to an independent arbitration panel in which the Court has no automatic role. But if the panel needs to, and a question of interpretation of union law is relevant to the dispute, it can ask the Court to resolve that question. It is then for the panel to apply that interpretation to the facts of the dispute and thus decide how the dispute should be resolved. Mr. Speaker, the divorce and separation of nations from long and intimate unions, just as of human beings, stirs high emotion and calls for wisdom and forbearance. It calls also for calm and measured evaluation by the House of the terms of the separation agreement in the light of the complexity and difficulty of the task it is intended to achieve. The gradual loosening and removal of the legal ties that have bound us to the European Union for 45 years will take time to work out. This agreement and the EU Withdrawal Act already passed by the House allow for the necessary time and legal means for that process to unfold in a peaceful and orderly way. I am at the disposal of the House to answer questions insofar as I can on these and other legal matters, and I commend this statement to the House.
Thomas-Symonds.
Now, Mr. Speaker, I'm of course grateful to the Attorney-General for his statement and for advance sight of it. But the reality of this situation is that all members are asking questions at a major disadvantage because they've not read the legal advice upon which this statement is based. And it is totally unacceptable to be in this position when aspects of the Attorney-General's advice have been selectively leaked to the press over the weekend. For example, Mr. Speaker, we understand that in a letter to Cabinet Ministers last month, it's been reported that the Attorney-General said, in respect of the backstop arrangement, the protocol would endure indefinitely if trade talks broke down. Now, today, in his statement to this House, the Attorney-General has talked about political factors that might, in his view, make the backstop temporary. But the reality is that that isn't the legal position. Perhaps he can confirm the legal position is as was in the letter, that it will endure indefinitely if the trade talks break down. Now, Mr. Speaker, on the 13th of November in this House, my right honourable friend, the Shadow BrExit Secretary, and I were both very clear that what was sought was the final and full advice provided by the Attorney-General to Cabinet on any completed withdrawal agreement made available to all MPs in good time for the vote on the deal. Offers short of that, including the Attorney-General's statement today, and a summary made by the government were rejected, and the House passed the moment unanimously. Playing games, shouts the Chancellor, the Conservative Party on the 13th of November couldn't get one of its MPs to vote against the motion. Not one. And the reality is, as well, that this document that has been produced is, in the Attorney-General's own words, a legal commentary that's been produced with his oversight and, indeed, approval. It is not the final legal advice to Cabinet. I should also say, frankly, Mr. Speaker, that a longer and more detailed explainer was produced alongside the withdrawal agreement than this document, it has to be said. Isn't the reality of this situation that the government does not want MPs to see the full legal advice for fear of the political consequences? And there is no point whatsoever trying to hide behind a Law Officers' Convention. The Ministerial Code and Erskine May are very clear that ministers have a discretion as part of that convention to make advice available in exceptional circumstances. What circumstances could be more exceptional than these? The economic, political and constitutional integrity of our country is at stake. And, Mr. Speaker, I will quote some of the legal commentary. I'll quote paragraph 82 of it, which says, and I quote, "The agreement does not contain any provision on its termination. In the absence of such a provision, it is not possible under international law to withdraw from the agreement unilaterally." So, straight question to the Attorney-General. Can he direct me, or indeed this House, to any other international treaty to which the UK is a party where it has no unilateral right to terminate it? Can he even name one? But it's actually, Mr. Speaker, more than that. Because Articles 1.4 and 2.1 of the Backstop Protocol are clear that its provisions shall apply unless they are superseded in whole or in part by a subsequent agreement. So, put simply, no, the with whole or in part bit was not commented on actually in the statement. And put simply, what that means is that parts of the backstop could become permanent even in the event that a trade deal was agreed. So, can I ask the Attorney-General directly, what is his view as to which parts of the backstop arrangement in this protocol he advises are most likely to become permanent? And can I also raise with the Attorney-General the impact on the Good Friday Agreement? And here I refer to page 305 of the withdrawal agreement, and this is what it refers to. The need for this protocol to be implemented so as to maintain the necessary conditions for continued North-South cooperation, including for possible new arrangements in accordance with the 1998 agreement. So can the Attorney-General tell the House, in his view, firstly, which new arrangements he believes would be in accordance with the 1998 Good Friday Agreement, and secondly, which arrangements he believes would not be in accordance with it? Mr. Speaker, in the first instance, it will be for you to rule whether there has been an arguable case of contempt for what we on these benches believe to be a failure to comply with the motion of 13th of November. For the sake of our economy, our jobs and our futures, all possible information should be made available to members of this House. The government should do the right thing and make this full advice available. With so much at stake for all our constituents, with 8 days to go before the vote on the deal, this House and this country deserves better from this government.
Attorney-General.
Well, Mr. Speaker, first let me say to the honourable gentleman, he has a far better than any advice I may or may not have given to the government. He can ask me, and all he has to ask, and he will receive, because I will give him a frank answer.
Order. I know the Attorney-General is very well able to... Order. Members must calm themselves. I know the Attorney-General is very well able to look after himself, but I simply gently counsel, gently at this stage, Order. I gently counsel members not to yell from a sedentary position in that way. The Right Honourable and Lady Gentleman would not, I'm sure, be accustomed to such treatment in a court. And if he were subject to it, I think the judge would take a very dim view. So he is order! He is in order. He is entitled to a courteous reception, and as the House knows from past experience, I will want to hear everyone who wishes to question him. But in the first instance, calm. Behave. The Attorney.
Mr. Speaker, it is very rare for the Attorney-General to appear to answer questions in the House on matters of law. And I am doing so, Mr. Speaker, so that members opposite, members on this side of the House, can have a full, frank and thorough opportunity of asking me, as the government's chief legal adviser, but also as an adviser to the House on constitutional and legal matters, what her legal position is. And I assure the House that if you ask me, if the questions are asked, I shall answer them candidly. The honourable gentleman told me that I hadn't said anything about the subsistence of the Northern Ireland Protocol. Let me make no bones about the Northern Ireland Protocol. It will subsist. We are indefinitely committed to it if it came into force. There is no point in my trying, or the government trying, to disguise that fact. The truth, however, is, what is the political imperative of either entering it or not entering to it? And that is a calculated equation of risk that each member of this House is going to have to weigh up, weighing it up against different alternatives. Now, the honourable gentleman also mentioned that I should answer whether other treaties are permanent. There are hundreds of treaties throughout the world that are permanent. If you do treaties on borders, if you do treaties on rivers, if you do treaties... The whole Vienna Convention has entire sections on permanent treaties. And if the honourable gentleman wants me to enumerate some, I'll write to him with them. I'm afraid I don't have them to hand. But there is an entire section of the Vienna Convention on permanent treaties. The question of whether we have a right to terminate under the Convention is a matter of construction. Let me make it plain. There is no such right to terminate if the Northern Ireland Protocol comes into force. The question of how likely it is to remain in force is a political judgment to be based on factors largely relating, as I have said, to in whose interests it would be to remain in it for longest.
Mr. Kenneth Clarke.
Well, firstly, Mr. Speaker, may I...
Order, it's rather unseemly for people to yell out, "Is that it?" Well, the Attorney, to be fair, has given a very full response. Members can make of it, order. Members can make of it what they will. But in any case, everybody should cheer up now, because we're about to hear the Father of the House, Ken Clarke.
Whether that will cheer people up or not, I have no idea. But firstly, Mr. Speaker, may I sincerely congratulate my right honourable friend on his masterly exposition of the facts and the law, which put paid to quite a lot of the paranoia and conspiracy theories that have been running around all too often in our European debate. And secondly, does he accept that it was central to the Good Friday Agreement, Belfast Agreement, that both sides committed themselves timelessly to an open border? And that is all wrapped up if we ever move to the Northern Ireland Protocol. And it would be quite shameful if either the European Union or the Republic of Ireland or the United Kingdom was given the right unilaterally to terminate that at a time of its political choosing. So it's perfectly sensible. Do you also agree that both the United Kingdom and the European Union will have reasons to hesitate before going into protocol? They may prefer to extend the transition agreement, and neither of the parties will have any political motive for staying indefinitely in that protocol. So he has, I think, in his exposition, and is this what he was trying to do? Got rid of all these theories, all the ones about the ECJ still being involved, it's obviously got to be in the rights of British citizens after we leave, and enable the House to get back to the real political debate that we have got to have in the next few days.
Mr. Speaker, I'm most grateful to the right honourable gentleman for his question. The truth of the matter is that this Northern Ireland Protocol would represent a solemn commitment to the people of Northern Ireland that this government will honour and respect the Belfast Agreement. I make no bones about it. I would have preferred to have seen a unilateral right of termination in this backstop. I would have preferred to have seen a clause that allowed us to exit if negotiations had irretrievably broken down. But I am prepared to lend my support to this agreement because I do not believe, I'm most grateful for those cheers of applause. I do not believe, Mr. Speaker, that we are likely to be entrapped in it permanently. I can give reasons why I say that, but the right honourable gentleman has already foreshadowed them. So I do agree with the right honourable gentleman. This represents a sensible compromise. It has unattractive elements, unsatisfactory elements for us. But the question for the House is to weigh it up against the other potential alternatives and to assess whether it amounts to a calculated risk that this government and this House should take in these circumstances, weighed up against the realities of the alternatives.
Joanna Cherry.
Thank you, Mr. Speaker. Mr. Speaker, the binding motion passed by this House on the 13th of November ordered the production of any legal advice in full, including that provided by the Attorney-General, and with a particular focus on the Northern Ireland backstop. Not a commentary, but the legal advice in full. The House didn't divide. The government effectively conceded that these were exceptional circumstances and that the normal, very important convention wouldn't apply, and so that ship has sailed. Now, the Attorney-General and I are both senior lawyers in our own jurisdictions, so I'm sure he won't want to insult my intelligence or that of the House by pretending that this command paper reflects in any way the nuanced advice that he will have given to the Cabinet, focused on particular questions such as those we saw it leaked over the weekend. For example, he's just said that he doesn't, it's not his belief that we'll be trapped in the backstop permanently. But this House, who has to take the final decision, not the Cabinet, is not interested in his belief. It's interested in his legal opinion. So can he confirm for me that I am right in saying that there is nothing, as a matter of law, which will not prevent the backstop from becoming the permanent UK-EU relationship in the event that neither side can agree a future economic relationship? That is the matter of law. And also, will he acknowledge this? He's a Democrat. The government are Democrats. They've gone on incessantly about the will of the people for the last 2 years, and they profess to believe in parliamentary sovereignty. We, sitting in this House, are the representatives of the people. We voted to see his advice, not his commentary, his advice in full. So will he give an undertaking that he will produce that advice, the sort of nuggets that were leaked over the weekend, but in full, before the rise of the House today and before the debate tomorrow? Or is he prepared to run the risk of being found in contempt of Parliament merely to protect the Conservative and Unionist Party against further internal strife?
I have the greatest of respect, if I may say so, to the honourable member. She's put her case rationally and reasonably. Let me deal with it, if I can, one by one. First, she asked me, is there anything to prevent it becoming, the protocol becoming permanent in the event of no agreement? As a matter of international law, no. The fact of the matter is, it would endure indefinitely, pending a future agreement being arranged. However, that does not exhaust all the matters of law. As a matter of European Union law, it would in those circumstances be highly vulnerable to legal challenge. It is widely accepted, including by the European Union Commission and Task Force 50, that Article 50 is not a sound legal foundation for permanent arrangements between future states. If negotiations irretrievably broke down, it would de facto become permanent, and it would therefore fall to be seriously challengeable in the Court of Justice of the European Union for being invalid. That legal certainty by itself is sufficient to promote the European Union to do a deal with us. Legal uncertainty of that type is profoundly detrimental to thousands, indeed millions of traders throughout the single market. That is one factor that convinces me, Mr. Speaker, that this risk is a risk worth taking.
Mr. Iain Duncan Smith.
Mr. Speaker, can I start by welcoming, without reservation, my right honourable and learned friend to his position. He knows that I have long since, many years, believed this is the post that he should have filled. Can I say, in welcoming his statement, can I simply say that I reference Note 8, page 6 of his document, and there it makes a reference in Note 6 to what is defined as good faith. And he references the International Court of Justice, and he won't mind if I just quickly quote this to him from that. He talks about how long should this be, what defines good faith. And it says, the failure of parties to reach an agreement 16 years after the conclusion of earlier negotiations does not in itself establish that either party has breached its obligations to negotiate in good faith. Now, he will know his right honourable friends on the front bench, one by one, have used good faith as their defence for being locked in to this whole problem of the backstop, and thus how we will then get out. Does he not therefore agree that, and would he answer this in this sense, is it that good faith is required for best endeavours as a matter of law or not?
Mr. Speaker, the duty of good faith and the duty to use best endeavours is a legally enforceable duty. But there is no doubt that it is difficult to prove, as I hear from a sedentary position. That is not to say it has not been proven. And the case reports of the International Court of Justice, as well as arbitral tribunals throughout the world, have recorded decisions where tribunals have found breaches of good faith duties. There would need to be clear and convincing evidence that the breakdown of communications was due to bad faith. Fully accept that. But if the European Union refused to engage with us, or was strung out the negotiations in a thoroughly unreasonable way, or failed to observe reasonable time limits, all of those matters would be hallmark marks of a possible case of breach of good faith. It is a meaningful legal obligation. And may I remind Mr. Speaker of the House this. We are dealing here with the United Kingdom on one hand and the European Union on the other. Their reputations in international fora, their reputations as a question of international law are at stake. If you put your name to a solemn legal obligation to negotiate something in good faith by a certain time limit, then it is a very serious obligation for you to acquit yourself of. It cannot just be played fast and loose with.
Mr. Nigel Dodds.
Thank you, Mr. Speaker. And can I say that I have the utmost and deep respect for the right honourable gentleman, and he knows that in terms of his approach to these issues and the discussions that we have had. But can I say that it is deeply unsatisfactory? He said this whole business was deeply unsatisfactory and unattractive, which makes me wonder why he's recommending it. And it seems to me a situation where we're now reliant on our learned friends to take cases in international courts rather than this sovereign parliament being able to decide when we can get out of these arrangements. Can the Attorney General confirm what he said, that this is an indefinite arrangement, that it can be permanent despite what some of his cabinet colleagues are saying in law, it can be permanent? And would he confirm, and I don't have time to go into all of this because, as other honourable members have said, we need to see the actual legal advice as requested by this House, and that must happen. Can he confirm that under Article 15 of the Northern Ireland Protocol, that the Northern Ireland customs arrangements means that Northern Ireland will form part of the EU customs territory and not the United Kingdom's, although a single customs territory is established between the UK and the EU? And would he confirm that under Article 4 of the Protocol, that there's a new right under international law, one that isn't in the 1998 agreement, for the EU to oversee certain aspects of the implementation of the Belfast Agreement? I add those as detailed points which I will follow up with him further in discussions. But the overall context of this is, as he has said, a deeply unattractive, unsatisfactory presentation, and he needs to therefore, rather than recommend this agreement, recommend that it be rejected.
Mr. Speaker, the right honourable gentleman throws down a gauntlet to me to re-examine my support for the agreement. And I don't mind confessing to him that I have wrestled with this question because I am a unionist. And any divergence between Northern Ireland and the rest of the United Kingdom I dislike. But I have had also to take into account that this is an arrangement which we can avoid. And secondly, that if we were in it, it would be as much an instrument of pain to the European Union as it would be to the United Kingdom. Because I tell the honourable gentleman, think of what the European Union is now accepting. It accepts Northern Ireland to have free circulation of its goods, not only into the single market, but to Great Britain. No other single market trader will have that advantage. Hundreds of single market traders throughout the European Union are going to resent the fact that if you are a Northern Ireland business situated 1 mile north of the border, your goods can flow smoothly into the single market and smoothly into Great Britain, while theirs can't. So there are real reasons, I say to the right honourable gentleman, which we can discuss at longer length, why I don't believe this will become a permanent solution. But let us suppose those negotiations broke down, or they took an unreasonable length of time. All around the European Union there will be single market traders experiencing the benefits that Northern Ireland can have, who will be induced by those benefits to consider, should we go on putting with this uncompetitive arrangement? And what are they likely to do? Why, they're likely, Mr. Speaker, to beat a path to the door of the Commission and the Court. And they're to say, didn't you say that Article 50 is not a sound legal foundation for this arrangement? And I tell you frankly, Mr. Speaker, they're likely to win.
Sir William Cash.
Mr. Speaker, on the issue of precedents, there are 5.
Order. I understand the House is mildly animated, but we must hear what the Chair of the European Scrutiny Committee wants to say. Sir William Cash.
Thank you, Mr. Speaker. On the issue of precedents, there are 5 where full disclosure has been made of the Attorney General's advice over the past 40 years as being disclosed for compelling and exceptional reasons in the public interest. Does my right honourable friend agree that he can, and in my view should, consent on his own independent account as Attorney General under the Ministerial Code to the full publication of his legal advice, given that, as cited in the Queen's Bench Division in July 2009, the then Attorney General's legal advice on the seminal Factortame case was disclosed, which dealt with the incompatibility of the European Community Act 1972 with an Act of Parliament, the Merchant Shipping Act 1988, which was then struck down by the courts, analogous to the legal status of the Withdrawal Treaty in relation to the European Union Withdrawal Act passed by this House in 2018 and with which that treaty is incompatible.
Well, Mr. Speaker, I say to my honourable friend, this is not a question of the lawfulness of the government's action, as it was in the publication of Lord Goldsmith's advice. This is simply a view on the legal effects of a particular agreement. There are hundreds of lawyers throughout the United Kingdom, I am delighted to say, who could offer a perfectly competent view on this agreement. I cannot see why there is anything exceptional about the current circumstances and about my advice. But let us suppose there were something exceptional about my advice. Well, I am here to be asked any question that the government has also asked. So all that the honourable and right honourable members opposite have to do is ask, and I will give them a frank answer.
Harriet Harman.
Thank you, Mr. Speaker. Will he acknowledge frankly to this House that publishing this paper on the legal position on the withdrawal agreement and his statement to the House today does not represent compliance with the motion of this House that was passed unanimously on November the 13th? And does that not represent a fundamental point of constitutional principle? Yep. It would be serious for any minister to resist a motion of the House, but that it should be the attorney going along with government defiance of the House when his very office is about our constitution, when he's the person in government whose job it is to make sure the rest of them stay within the rules. How can he do that if he himself is acquiescing in breaking them? He has in his statement rightly acknowledged that he has a duty to this House as well as to the government, and that his duties involve giving legal advice to the House. It's in our standing orders that he's legal advisor to the Committee on Privileges. So how can we have a situation where the attorney allows the government to openly defy the will of the House? Absolutely. The government have got a choice. They can either comply with the motion of the House or they can seek to change it, but they cannot remain in defiance of it. It's his responsibility to tell them that, will he?
I'm grateful to the right honourable lady for that question. The truth is, and learned lady, thank you. The truth is that I am caught in an acute clash of constitutional principle. A minister is obliged to have regard to the public interest and the national interest. The House, let us suppose I had given any such advice as has been requested by the right honourable, the honourable and learned gentleman who sits opposite. Let us suppose I had. Let us suppose that that advice had covered all sorts of matters, including our relationships with foreign states, including arguments that might be deployed in the future, the strengths and weaknesses, including matters of acute importance to this country. Would it be right for the Attorney General, regardless of the harm to the public interest, to divulge his opinion? I say to the right honourable lady, it wouldn't. There is no procedure by which this House can have redactions or can entertain circumstances in which, as a judge would, they would weigh the competing public interest against the interests in disclosure. She knows what I mean. Therefore, I cannot take a step that I firmly and truly believe would be contrary to the public interest. And I ask the House to understand that it is only that consideration that is motivating me and this government in declining at this stage to break the convention that applies to both sides of the House when they are in government. There is nothing to see here. Ask. What?
Order. Can I gently appeal to colleagues to lower the decibel level? You don't have to look into the crystal ball. Order! Mr. Russell-Well, you don't have to look into the crystal ball when you can read the book. The evidence is that The evidence is that I always call colleagues to ask questions, and the attorney has indicated his readiness, as indeed he must, to take those questions. So you'll all get a chance, but please let the answers be heard. The attorney.
On all relevant points of law, I ask the Right Honourable Lady to accept. On any relevant point of law, I will give this House a stark and uncompromising and completely frank view on that point of law. And therefore, there is no real significance, I would suggest, in if I had given advice, in that advice being disclosed, since this House has the opportunity of asking me directly.
Mr. Dominic Grieve.
Thank you, Mr. Speaker. My right honourable and learned friend is firstly to be commended for his statement, but also for the document that has been produced, which is rather fuller, I have to say from my own experience, than any advice he might ever have been called upon to produce. Could he take this opportunity, because it might be helpful to the House, to confirm that there is nothing in this document which is incompatible with any advice which he gave to the government? Because I would have expected that he would not be in a position to endorse any such document if it were at variance in that form. And secondly, turning away from that principle to the content, might he also wish to comment on the provisions specific to Northern Ireland between paragraphs 25 to 29, which appear to me to show quite clearly that under the protocol it would be possible to end up with a situation where there were in fact checks and controls between goods passing between Northern Ireland and the rest of Great Britain.
I'm grateful to my right honourable and learned friend. He will understand that if I were to make the express confirmation that he did, I would be by that means disclosing what advice, if any, I had given. But I think what the House can understand, unless, of course, it's to be supposed that I would tailor my advice according to my audience, which I assure the House I would not, that there is no matter that they could ask me a question upon which I am likely to have given a different answer to any other party who might have asked me in the course of these negotiations. Therefore, all in candour, the House has to do is ask. Now, in relation to the second question that my right honourable friend has asked, it is true that there would be regulatory divergences, as there are within sovereign states throughout the world, between one part of the sovereign territory of the United Kingdom and another. But those divergences could be kept to a minimum, and they involve, on my investigation, some 15 forms of product in respect of which checks might have to be carried out at the border. Those 15 forms of product are largely phytosanitary goods, in respect of which, in any event, checks, in many cases, are already carried out at the ports of Northern Ireland. Therefore, while that border would exist, and I find it myself distasteful, nevertheless, they are mitigable, and the question again is whether that is a feature that should lead us to decline this deal, which is the best way, I firmly believe, of ensuring that we leave the European Union on March the 29th. And that is the solemn responsibility that this side of the House, and I believe some on that side of the House, believed they had. This is the deal which will ensure that happening in an orderly way with legal certainty.
Mr. Hilary Benn.
Thank you very much, Mr. Speaker. Can I say to the right honourable and learned gentleman that there is something to see here? If the government can decide which votes of the House of Commons to respect and which to ignore, as you said, Mr. Speaker, when ruling on a point of order on the 13th of November, it was not the opinion of the House of Commons that it wanted the full legal advice to be released, but the will of the House of Commons. Then what does democracy mean in this place? Now, I have a question to him on which I want his legal advice. As you will be aware, the withdrawal agreement is legally binding, but the political declaration is not. Can he draw to the House's attention a single example in international law where a failure to act in good faith has successfully compelled one party in a negotiation to reach an agreement as extensive as the one the government hopes to achieve and which is set out in the political declaration covering trade in goods and services and security and foreign policy and broadcasting and data and cooperation on a wide range of matters? Because if there is, I would very much like to hear about it.
Well, the right honourable gentleman points out that we are in a unique situation. There has never been a case in which a country has seceded from the European Union, and there's never been a case where 45 years of legal integration of a state the size of the United Kingdom is to be untangled, and that will take time, and it must be done in an orderly way. So I'll write to the right honourable gentleman, if I may, if there are any specific examples that those who assist me can help. But the fact of the matter is, I doubt it, in the frank answer, because we are in this extraordinary and unique situation. Now, may I address the first part of his question? I repeat, what does he expect us to do? When he was a member of the Cabinet, if he believed that to take an action would be fundamentally contrary to the public interest of this country, he would find it, I suspect, a very difficult situation to resolve. The House's resolution is entitled to the greatest of respect, and the government and I personally am inclined to do as much as we can, to go as far as we can, which was why I come to the House today. And it has barely happened in history more than a few times in the last 50 or so years to answer the House's questions. But I cannot take a step that in conscience, I believe, would be against the public interest. And not only against it, seriously, potentially harmful to a fundamental constitutional principle, as well as the temporal interests of this country in the midst of a negotiation.
Mr. Dominic Raab.
Can I welcome the Attorney's transparency in coming to the House, both in his oral statement and the memorandum. Can he confirm that the Article 20 review mechanism necessitates that the EU agree to the UK exiting the backstop, even if the negotiations have dragged on for many years or indeed have broken down? And secondly, that whilst the Article 50 basis for the backstop is meant to be temporary, it might well take some 10 years for it to be struck down by the European Court. And if he thinks that that's too long, could he give the House his best estimate?
I think my right honourable friend's question, the first part of it, related to Article 20. Article 20 permits both sides to consider, even when no final agreement has yet been reached, whether alternative arrangements might suffice to protect the stated objectives of the Northern Ireland Protocol. And if they do, both sides could agree in order to put in place those alternative arrangements before any final agreement had been reached. It's important to remember that when one says final agreement, it is of course possible, indeed likely, that this may be a series of agreements reached at different times. So first, my answer to my right honourable friend is that it creates that ability, but it is not a unilateral right of termination. It does not give us a right to walk away. It creates a procedure and obliges the European Union to consider alternative arrangements that are not part of a final deal. I think my right honourable friend then went on to ask me about Article 50 and the time it might take. I think the period of years that he gives is probably far too long, but it's impossible to say. What one can say is, long before any case was brought, the pressure that was bringing those cases to the court would be telling upon the governments of the member states and upon the European Union. The legal uncertainty would be intense, and it is a real factor that this House must weigh up in considering whether the protocol is something that it wishes to support.
Yvette Cooper.
I'm trying to understand the Attorney-General's arguments to earlier questions. He seemed to be saying that the Northern Ireland Protocol including the close relationship with the single market, membership of the single customs territory, was such a good deal for UK businesses that EU member states would hate it and would be desperate to bring it to an end as soon as possible. Is that his view? Is that the government's view? And if so, is he now arguing for us to stay in a single customs territory indefinitely and to keep a close relationship with the single market?
What I do say is that the customs, the arrangement under the backstop, produces the following advantages. We pay not a penny. We have free access to our goods in fiscal and tariff terms to the European Union. And yet, the regulatory framework that we have to observe is dealt with by way of non-regression clauses that are not enforceable either by the EU institutions or by the arbitration arrangements under the withdrawal agreement. They are policed solely by British courts and British authorities. In those circumstances, what does that mean? It means they have split the four freedoms. They have created a situation where we can have regulatory flexibility that they can't. They have granted access to the single market for no contribution, without free movement, without signing up to the fisheries policy, without signing up to the common agricultural policy. So for all of those reasons, what I say to the Right Honourable Lady is that this will be, if it is painful to us, as painful to them. Where we want to end up is an arrangement that suits us both. This suits neither.
Sir Michael Fallon.
With regard to the Northern Ireland Protocol and paragraph 11 of his helpful annex, could the attorney advise us what might constitute the clear basis, as he puts it, for a finding of a breach of duty of good faith?
Yes, Mr. Speaker, evidence of wilful transigence, evidence of refusal to engage, evidence of refusal to entertain alternative proposals, alternative means of achieving the outcomes that both share. That type of evidence cumulatively could amount to a case of bad faith. But each situation is fact-specific. It's not one it's possible to identify beforehand. Those are the kinds of things that would be relevant.
Kate Hoey.
Speaker, the Attorney-General has been very honest, I think, in the downside of this backstop. And that's even without the legal advice, so we dread what would actually be in it if we did see it. But could I ask him about the Secretary of State for Northern Ireland, who on Sunday, in the Inside Northern Ireland Politics with Mark Davenport, actually said, even if the backstop kicks in, Great Britain will stick to the same rules as Northern Ireland. Now, would the Attorney-General have a word with her? Because she's going around Northern Ireland on a tour and saying some things which are actually not accurate and giving the people of Northern Ireland the very wrong impression about what this agreement means.
Well, Mr. Speaker, the regulatory regime in Great Britain will be a matter entirely for the government of the United Kingdom, and it is permitted and agreed under the protocol that it can maintain its regulatory regime in the way it chooses, in which case it could choose to maintain, as I've no doubt it would wish to do so, regulatory parity with the position in Northern Ireland. That is all the Secretary of State is saying, and I see nothing controversial in that.
Sir Oliver Heald.
Can I commend my right honourable friend on the statement which he's made? Does he agree with me that in international law, concepts of good faith, concepts of using your best endeavours are very important indeed, because right at the heart of international law is the idea of a rules-based system which good countries aspire to. And does he agree with me that it's therefore very important both to the UK and to the EU that they should show good faith, that they should use their best endeavours, and indeed if they didn't, when it came to the point which has just been raised by my right honourable friend for Sevenoaks under paragraph 11 here in the references to the protocol, it would be an absolute disaster, but either for the UK or the EU to be found not to be in good faith.
I do agree with that, Mr. Speaker. I think that the duty of good faith is a very solemn, well-understood one in international law. It would be an astonishing thing if the European Union were not to negotiate in good faith, particularly after the act of good faith that this country, in concluding this agreement, will have committed itself to. So I think it isn't something that simply could be ignored. But I fully accept, this is not a unilateral right of termination. And it would not be easy to establish against an organisation of the type of the EU, against it, bad faith. It would never happen, because I don't believe that the European Union would descend to the kind of behaviour which it would be necessary for them to behave in if a good bad faith claim could be brought successfully.
Mrs. Helen Goodman.
Mr. Speaker, on the 13th of November, did the Attorney-General advise the Chief Whip that government ministers should vote against the motion? And if he didn't, why not?
I only wish that I had the influence that the Honourable Lady believes that I have. I did not advise the Chief Whip, and the Chief Whip, I don't suppose, would have taken the advice even if I'd given it.
Will you publish the advice?
Dr. Julian Lewis. Mr. Speaker, I'm about to attempt to achieve the ambition of a lifetime and get a one-word answer out of a lawyer. Is it possible that the United Kingdom could find itself locked in the backstop forever against our will?
Yes.
No.
Mr. Frank Field.
Does the attorney agree? Does the attorney agree that if a motion like the one that I've tabled on the order paper, giving this House sovereignty on when we should leave the backstop, should we enter it, then we would, as a country, have a degree of certainty which he's been unable to supply today? And if the government goes down to defeat next week, would you suggest that should be top of the Prime Minister's negotiating list with the European Union?
General. Right Honourable Gentleman, I have enormous respect for him and his suggestion, and I realise that other Honourable Members, Right Honourable Members, are considering similar things. May I simply say this. What we cannot do is anything that is incompatible with our obligations under the withdrawal agreement. Any amendment to the meaningful vote that would introduce a qualification to our obligations under the agreement would be likely to be viewed by the European Union as a failure to ratify it and would justify non-ratification on their part. In the circumstances that he suggests, frankly, we will be plunged into such great chaotic disorder that I very much hope the House will think and reflect carefully before doing so.
Mr. David Jones.
My right honourable friend has pointed out that the best endeavours clauses in the withdrawal agreement impose a duty upon both sides to proceed with the utmost good faith in seeking to achieve an agreement at some time in the future. He has said also that these are obligations that are judiciable and enforceable. Could he please tell the House, as a practical lawyer, advising it, as he has kindly offered to do, whether this is a matter about which the House should be relaxed or whether we should proceed at our peril?
As he knows, the job of any lawyer for any client is generally to assist the client make decisions as to the balance of risk in any decision that they are about to take. There is no question that the absence of a right of termination of the backstop presents a legal risk. The question of whether it is one this House should take is a matter of political and policy judgment that each one of us must grapple with. The House has heard, and for reasons I'm not going here to expatiate upon, I have taken the view that compared to the other courses available to the House, this one is a reasonable, calculated risk to take. Other members of this House must weigh it up, but that is my view.
Maria Eagle.
Mr. Speaker, in response to some questions from honourable members of this House today, the Attorney-General has asserted that it would not be in the public interest, in his view, to meet the terms of a resolution passed by this House that was an effective resolution that was passed unanimously by this House. Can the Attorney-General really take that view? And was it not incumbent upon him and the government to vote against that resolution if he thought that it was against the interest, the public interest, to publish his advice in the way in which he's asserted today?
I fully understand the understandable indignation that the Right Honourable Lady has, because the truth is, it is a curious situation that we are now in where no vote has been passed against that motion. But I ask the Right Honourable Lady to reflect on this. Let us suppose the government had voted against it and lost. What position would that place us in? It would place me in exactly... It would place me...
No, the Honourable Lady has already asked her question with considerable force and alacrity, and she's now not only inclined to chunter from a sedentary position, but she seems to be laughing and in a state of some uncontrollable mirth. I advise her to control herself. The Attorney-General.
If the vote had been lost instead, then precisely the same position would pertain, which is that the Attorney-General and the government would be faced with a clash of constitutional principle. Of course, the government wishes to do all it can, which is why I am here today, to answer as candidly and frankly as possible the questions of the House on any matter that it wishes to ask. But if I am satisfied and convinced that any disclosure of the kind the House has asked for would be contrary to the national interest, I cannot comply with the House's request. What I urge the House is to understand that I am doing everything I can, as is the government, to fulfil the spirit of the request, no matter upon which this House inquires will be dressed up, disguised, or in any way downplayed. Nothing will be held back.
Mr. Jacob Rees-Mogg.
Thank you, Mr. Speaker. My right honourable and learned friend has been enormously gracious in being willing to answer any question the House may have on legal matters. And there are many questions that we all have to ask that may not be easy to put in one short question. But unfortunately, he does not answer the basic point about denying a motion passed by this House, saying that it in his view that is not in the national interest is not good enough. When the government loses a vote, it must follow the will of this House under an humble address according to all precedent. It is no longer a matter for the government to judge. It has been decided by this House, which is a higher authority. I would therefore urge him, in spite of his generosity in answering questions, to go back and release the advice asked for by this House.
Well, of course, a request from the quarter from which it has just come, I will always want to re-examine the assumptions I've made. But I have to say to Mr. Speaker, to my honourable friend, the problem here is that it cannot be right that the House, by means of such a motion, has the power blind to call for any matter which has been discussed in connection with the government of this country. Where does it end? Just wait a minute. I'm trying to do my best. So where does the limits of this power end? Does it extend to cabinet minutes? Does it extend to the papers of the Secret Intelligence Service? Is the House, by means of this motion, to command any paper of any kind, central to the interests of this nation, without even being able to check that by its release they are causing or might cause severe damage to the public interest, I invite the honourable member to consider the implications of the absolute rule that he is talking of. It cannot be right. And if one looks at previous versions, if one looks at previous Erskine Mays, one sees that the motion to return is confined to documents of public and official character. And if there are good reasons of public policy why those papers should not be disclosed, then the House will either withdraw or rescind its motion. Now, in this case, I am convinced that in order to disclose any advice that might have been given would be fundamentally contrary to the interests of this country. It's no use the baying and shouting of members opposite. What I am trying to do is guard the public interest. That's all. And it's time, and it is time they grew up and got real. If there were a single item which I thought might be politically embarrassing, I would have no truck with the idea that this advice or any that I might have given should be disclosed. It is because the public interest is at stake. What part of that proposition is the other side incapable of understanding?
Caroline Lucas!
At stake today are really serious issues, and yet this House is descending into farce, into some kind of amateur dramatics. This is serious stuff, Mr. Speaker.
Order. Mr. Chalk, you are a most cerebral and ordinarily a most genial individual, and you also practice in the courts, or have done, as a barrister, I'm sure, in a most dignified and respectful manner. And the Honourable Order, this is a serious point, just as the attorney is entitled to be treated with respect, every member of this House, Order, it will go on as long as it takes, I couldn't care less, every member of this House is entitled to be treated with respect in this matter, and the Honourable Lady will be heard. The attorney talked about braying and shouting, and he was justified in complaining about being subject to braying and shouting, a point I have already myself made. The same goes for members responding to the Honourable Lady. She will be heard. What part of that proposition can some people not understand? Caroline Lucas.
Thank you, Mr. Speaker. I was just saying that these proceedings were in danger of descending into farce. The Attorney-General repeatedly says that he will subject himself to what he calls full, frank and thorough questioning. But he knows as well as we know that our capacity to do that questioning is seriously undermined by the fact that we do not have the full legal advice in front of us in order to interrogate it. He talks about the national interest. It is precisely because these are issues of national interest that we wish to see the full legal advice. So will he go away and look again at the principle that in exceptional times transparency should take precedence and therefore produce the full legal advice for this House?
In all earnestness to the Honourable Lady, when I gave my statement, she will have noticed that what I have said is she must understand the process by which law officers give their advice. There may be no such full legal advice. Law officers are consulted ad hoc, on the hoof, in fast-developing circumstances. And the fact of the matter is, that is what the statement says at the beginning of it. The fact of the matter is, I am here to answer her questions. And of course, well then I will see the Honourable Lady at any time at her convenience to ask any question. What I can't do is breach the Constitutional Convention to a client, in this case the government, particularly if I believe, as I do here with all candour and sincerity, that it would be contrary to the national interest in the course of a negotiation. which, when discussions about strengths, weaknesses, future strategies, all of them might be involved. So there's a sedentary position from the right honourable gentleman. It's not arrogance. I wish that I could comply with the request of this House, but if I did, I sincerely believe it would not be in all of our interests. Now, in a court, that matter can be resolved by a judge. But in the procedures of this House, and it may very well be, we need to look at the procedures. In the procedures of this House, there is no such arbiter. Therefore, the House says that I should disclose. But I believe that the public interest compels me not to. I'm sorry.
Sir Desmond Swayne.
The backstop is in the agreement at the assistance of the EU, and it affords them a huge advantage, a huge leverage, when it comes to our determination never to be in it when we negotiate the future arrangements, doesn't it?
The answer to my honourable friend's point is no. If anything, the leverage, I believe, is in the opposite direction. We will have the French, the Belgians, the Dutch. They all want access to our coastal waters. But this is outside the backstop's purview. Therefore, they will want it. We will have to negotiate. We're outside. We don't have to pay a penny. It's legally uncertain. We have regulatory flexibility in Great Britain. In Northern Ireland, they have free circulation of their goods, both to the GB and the European Union. I tell you, if the honourable gentleman wants my frank view, and he knows I supported leaving the European Union, I think the European Union will be very keen indeed to do a deal with us. That's what I believe.
Order. Order. No one enjoys the right honourable learned gentleman's eloquence more than I. Let's share it with the whole House. Thank you. Liz Saville Roberts.
Mr. Clarke, the British government insists it has the right to take privileged legal advice, which remains private between lawyer and client. I recall the Labour government using the exact same excuse during the Iraq War. Now, in light of the confessed damage any Brexit deal will cause, I beg, who is the client? Shouldn't the Attorney-General learn from the mistakes of the past and discharge his solemn and constitutional duty as a humble servant of Parliament and a humble servant of the public, and publish? If not now, when?
Well, I should just point out to the honourable lady that the advice of Lord Goldsmith was published 2 years after the event. What the House is now asking is that the advice, if any, given by the Attorney-General should be published in the middle of the negotiations, where we will be still needing to deploy many of the arguments connected with the withdrawal agreement potentially in the future. Secondly, the advice of Lord Goldsmith was on a question of the lawfulness of the government's action. This is not a question of whether the government acted lawfully. This is simply a question of whether the government is acting wisely, on which matters of members of the House can disagree. So there is a fundamental distinction between the position when the advice of Lord Goldsmith was given in 2003 and the advice today. The advice that the Attorney-General and the law officers give on a matter like this could be replicated by any lawyer of reasonable competence. Why, the right honourable gentleman for Holborn and St Pancras could pop down to his chambers and find half a dozen lawyers there capable of giving the same advice that I might have given on these points, probably better. So the truth of the matter is, what is so important about mine? The truth is, well, it's very good. It's very good, Mr. Speaker of the House, to attribute such importance to the Attorney-General. But the reality is, in terms of substantive effect, there are hundreds of lawyers who could give this opinion. Lord Goldsmith, let me finish. Lord Goldsmith. The
honourable lady shouldn't rant from a sedentary position. You asked her a question with considerable force. Let's hear the response.
Lord Goldsmith was the Attorney-General has a very special role when the lawfulness of the government's action is at stake. There, it's true, he occupies a central role, because if he says it's not lawful, then the government cannot act contrary to his advice. But in a case like this, the essential question before all of us, I say to this House, is a political question, not a legal question.
Dame Cheryl Gillan.
Mr. Speaker, on whichever side of this House you sit, those of us that have been in government know that it is very important that there is a safe space in which law officers and civil servants can give advice to ministers. And I fear today we are trying to breach that convention, which could be very dangerous for our system. It is extraordinary to me that people would prefer to have a piece of paper produced to them, which they have clearly been told may contain information which damages the national interest, rather than have the Attorney-General in front of us, and, in my opinion, who is giving us further and better particulars and answering all questions in a full, frank and fair way.
I think the right honourable lady's finished, no?
Well, Mr. Speaker, I was just going to say, could the Attorney-General confirm that there is nothing in that written advice that he hasn't covered today that, if it was revealed, would be damaging to the national interest?
On all points of law that this House has asked me, or any point that arising from this withdrawal agreement, I will give the same view to any person who asks me.
I just advise the House that 21 backbenchers have questioned the Attorney-General in 50 minutes. Believe me, I know these things as I sit in this chair for many hours, and it's my privilege to do so. That is a much, much slower rate of progress than is customary. So I appeal to colleagues to ask short questions, and the attorney, to whose mellifluous tones I never tire of hearing, to be appropriately pithy in reply. Tom Brake.
Precedent set by Lord Goldsmith, whose legal statement was clearly spun and cherry-picked. Without seeing the full legal Brexit advice, why should any MP here today believe this statement isn't simply massaged and designed to bolster the government's position and deny MPs on all sides of the House full access to the legal advice this House has demanded? And I'm afraid to say the Attorney-General has rather contemptuously and rather theatrically, as if he were performing Rumpole of the Old Bailey, dismissed and refused to provide us.
I can only tell him that I have not massaged the advice. I've given it absolutely as I see it, absolutely starkly. I will give that same advice if anybody asks to come and see me, but what I cannot do is breach the fundamental constitutional principle which I believe would be contrary to the public interest to break. So I can only invite the honourable gentleman to accept that I have given this advice as candidly as I possibly can. I can't say any more if he doesn't accept it.
Steve Baker.
An amendment was tabled to the humble address, which was highly sympathetic to my right honourable and learned friend's position, but it was not selected, it was not passed, but the motion unamended was. And therefore, whatever he's just argued at the dispatch box, the position is, as my honourable friend for North East Somerset set out, he is under an instruction. If he wishes to change the position in this House of Commons, will he move a motion in this House to support the position which he has just set out?
I will certainly give that point consideration that my honourable friend has given, because that may be one way forward. And at the conclusion of the proceedings today, I shall consider what the position will be, and I shall be writing to Mr. Speaker with those conclusions and proposals.
George Howarth.
The Right Honourable and Learned Gentleman says that it would not be in the national interest to share his legal advice with the House. Doesn't he realise, though, that in just over a week's time,
this House is going to have to decide what is in the national interest. So how are we supposed to do that when he won't tell us what his legal advice is?
But with respect to the honourable gentleman, I didn't. The honourable gentleman has had my legal advice. What it hasn't had is if there is any kind of document that might have been created or my oral advice in any other circumstance to government ministers, to the cabinet, if such exists. Now, but he's had my legal advice. Yes, he's had the advice and can have it at any other point on matters of law arising from the withdrawal agreement.
Victoria Prentis.
Does the Attorney General think that it would have been possible to sign a withdrawal agreement without the inclusion of the backstop?
No.
Mr. David Hanson.
Thank you, Mr. Speaker. I'm not a lawyer, so I'd welcome the Attorney General's advice. This House passed a unanimous motion. It was not opposed by him or his government. It is binding on this House. Could he give me some legal advice as to what my rights are now?
Well, I think the honourable member has plenty of opportunities to consult others than me. But ultimately, what the House will have to decide is whether or not an Attorney General or a government that is seeking to protect the public interest is in contempt of its motion. When what it has done is sought to comply with the spirit of it to the maximum possible degree, where it has put its legal adviser at the disposal of the House, instructed it to give full, frank, complete answers to any question asked on the matters of law that any legal advice would have been likely to have covered.
Mr. Stephen Crabb.
Mr. Speaker, the attorney said that he would rather that there was a unilateral termination clause in the Northern Ireland Protocol. Earlier at the Select Committee, Ollie Robbins appeared to concede that one such clause had been drafted, had been tested with EU negotiators, but ultimately not deployed in the negotiations. Could the attorney confirm whether he was asked to provide legal advice on a unilateral termination clause and whether the decision was a political or a legal one not to include it in the negotiations?
I can't, without breaching that convention, disclose whether or not I was asked to advise on any particular point. But what I can say is that the question of termination clauses was most certainly raised in the negotiations, but the European Union declined to entertain those termination clauses. They did so because the backstop is envisaged as an absolute guarantee that in all circumstances, including those of no deal, there would be no hard border at the Northern Irish Republic of Ireland border. Therefore, to have a termination clause would be a contradiction in terms. It would not be a guarantee if you can walk away from it. That is the decision the House must face. And in the light of that, it must decide whether this is an arrangement into which it should, given the alternatives, enter.
Iain Paisley.
Thank you, Mr. Speaker. Can I thank the Attorney General for his absolute candour and how he's presented this to the House this evening. But it is the case that the stark reality of what he has set out to any person living in Northern Ireland is that as a result of Northern Ireland ending up in this backstop, which would be utterly shameful, Northern Ireland will become an annex of the United Kingdom when it comes to trading relations during the backstop period. Yep. I quote to him the document that he has put in the table office today, that these provisions apply to measures that affect trade between Great Britain and the EU, but not trade between Northern Ireland and the EU. In fact, we would have to comply with another regime. How could any unionist sign up to that?
Yep.
The original proposal of the European Union, as the honourable gentleman opposite will know, was that Northern Ireland should reside in an entirely separate customs territory. The government took the view That was wholly and completely unacceptable. Why? Because there is virtually no sovereign state in the world that has separate customs and fiscal tariffs within its own sovereign territory. But there are many nations throughout the world in which different provinces and parts have regulatory divergence. The regulatory divergence in this case can be minimized to an almost, if not wholly, invisible extent. Furthermore, we do not wish nor expect to be in this arrangement. We can extend, under Article 132, the implementation period. And if we are close to doing a deal, or even reasonably close, no doubt that is a choice which we will have to consider. So I say to the honourable gentleman opposite, I understand entirely their feelings of concern, even distaste. But this is a question affecting the whole of the United Kingdom and its interests. And so vital is the fact that we should have an orderly exit from the European Union, that as people who hold the United Kingdom's union at its heart, I would urge them to consider supporting this, for it is our means out of the European Union. A means out of the European Union. The limited extent to which Northern Ireland would remain relates to goods only. Goods, agri-goods, goods only. Goods only. So I would urge them to consider the interests of the United Kingdom. I fully understand the dissatisfactory elements of this agreement to them.
Sir Christopher Chope.
Thank you, Mr. Speaker. My right honourable and learned friend has told my honourable friend, the member for Preseli Pembrokeshire, that the European Union is refusing to allow a get-out clause out of the permanent backstop. But my right honourable friend has told us that he doesn't believe that the permanent backstop is sound in European Union law. Can this matter be resolved by a reference to the European Court of Justice in the same way as the European Court of Justice gave its opinion in relation to the relevance of the Lisbon Treaty requirement that the EU should sign up to the European Convention on Human Rights? It gave its opinion on that and said that he didn't think it was compatible with the EU treaties, despite the fact it had been signed up in that particular treaty. Can something similar be done here to remove the uncertainty?
There is nothing to prevent a case being brought to the Court of Justice of the European Union on whether any agreement that is signed by the European Union is compatible with the treaties. But I would point out that, as I said earlier, the time at which this becomes legally vulnerable, or most legally vulnerable, is the time at which it becomes de facto not simply temporary, but permanent. And it is at that point where it may be that the problem crystallises in connection with Article 50 and its use to conclude this agreement. The legal uncertainty of knowing whether or not it would survive such a challenge is one of the factors, I believe, that will impel the European Union to conclude an arrangement with us in expeditious time.
Thangam Debbonaire.
Mr. Speaker, it appears to me that the Attorney-General is treating this House and everyone we represent with a great deal of indifference at best and contempt at worst. So I have to ask the Attorney-General, at what point did he advise the Chief Whip that he would not comply with the terms of the humble address? Was it before, during, or after the point that this House expressed its will in support of that humble address, requiring him to publish full advice?
The decision as to whether or not any law officer's advice, should any have been given, is a collective decision of the government. The attorney must consent, but first it is a collective decision of the government. And I hope that answers the question. If she asked me about the Chief Whip, I had no discussions with the Chief Whip on this subject. None were sought.
Vicky Ford.
Thank you very much, Mr. Speaker. As someone who was born in Northern Ireland, I hold the Belfast Agreement as very precious because it safeguards my birthright to be accepted as British or Irish or both. And on November the 13th, I listened very closely when the opposition spokesman changed his own interpretation of that motion no less than 4 times. So can I thank the Attorney-General for making it so clear that, in his view, the backstop is not a risk? And can I ask him, on a totally separate issue, if we were in the backstop, would we have control of our fishing waters?
I'm grateful to the honourable lady. Can I say candidly, I did not say it was not a risk. It is a risk. It is a risk. But it is a risk that I believe weighed against the other risks of utter chaos or losing our departure from the European Union on March the 29th, or the consequences of so grave a breach of faith with the people of this country as to ignore the outcome of that referendum. I believe it's a risk that we have to take. Secondly, she asked me about fishing, and of course she is right. In the backstop, there would be no access to our waters other than that we didn't agree to.
Catherine West.
The Attorney-General has made many references to his passion for unionism. What is the legal assessment that he's made for different parts of the UK if the Northern Ireland Protocol comes into being? For example, devolved administrations or other regions of England?
General. The whole principle of devolution, of course, is that there will be divergences between parts of the United Kingdom which are governed by devolved assemblies. Unfortunately, in the Northern Ireland case, those devolved assemblies are not at present functioning. So it's reasonable, and were those institutions functioning, it may very well be that they would have been given a central role in these matters. Because, of course, Northern Ireland shares a land border with the European Union, and therefore calls for specific measures, which do not apply in the same considerations that apply to other parts of the European Union.
Mr. Philip Davis.
Mr. Speaker, the Prime Minister has said on many occasions that if we were to leave without a deal, we wouldn't pay any money over to the European Union. The Chancellor has said on many occasions that we are legally obliged to pay the money over to the European Union. So, can the Attorney-General tell us what legally we are obliged to pay over to the European Union to leave, and which treaties he's referring to when he gives us that advice?
General. The position on money is really this. The view of the government, and my view, is that we would have obligations to pay a certain amount of money were we to leave the European Union without a deal. The European Union, the House of Lords European Union Committee concluded that there would be no obligation under EU law. That is a stronger argument, not necessarily uncontestable argument, as to our obligations under EU law. But it also concluded that we might have obligations under public international law, and with that I agree. There is an argument that under public international law we would not have an obligation, but I think it is an argument unlikely to be accepted by any international tribunal. And therefore my view is that we would owe a presently unquantifiable sum were we to leave the European Union without a deal. It is impossible at this stage to say how much. It is true that the European Union is not a member state and is not a state, and therefore is unable to take the case to the International Court of Justice. And therefore it might be difficult to enforce the public international law obligation that existed. However, I ask the House to reflect that if this country, acknowledging that such obligations probably or do exist, did not pay them, it would be likely to cause the deepest resentment, just as any of us who are unpaid a debt. If we leave a club, we pay the bar bill. If we didn't pay the bill, we're not likely to get a lot of consideration from the other side.
And Diana Johnson.
Mr. Speaker, I wondered if the Attorney-General could help me. He said that in exceptional circumstances, legal advice can be disclosed. And he's also talked this afternoon about the unique circumstances we're in and the extraordinary circumstances we're in. So what's the difference? Why are we not in exceptional circumstances?
The Attorney-General, by definition, is only called upon to advise on matters that are exceptional or in exceptional circumstances. The question here is, what requires the advice of the attorney to be disclosed?
In Lord Goldsmith's case, the issue was the action of the government lawful? And the action of the government could not be taken if the attorney had not signed off on it, because it would be contrary to the ministerial code. So the circumstance here is that the House has available to it a wide range of highly competent legal advice, just as good in many as mine, just as good as those who advise me. And so there is nothing essential, I would suggest to the House, about the advice of the attorney being disclosed in this case. But there is something that could lead to a severe damage to the public interest. Now, one honourable lady opposite said to me that I was being arrogant. I am not. I am trying genuinely to protect the public interest. The last thing I want to do is to be at odds with this House. I've been a member for 13 years. I would very much like to ensure that the House is satisfied, which is why I am here today answering these questions.
O'Neill.
I'm glad that the attorney draws the distinction with the Iraq case, but surely the act of withdrawal from the European Union must be lawful because it is authorised by statute in this case. But as to his advice, isn't it reality that very often any lawyer has to advise as to the difference between a theoretical risk and a practical risk? And do I take it that the attorney's assessment is that the likelihood of a theoretical risk being crystallised because the European Union is prepared to breach international law by breaching the best endeavours and good faith clauses, and at the same time also risk breaching its own union law by relying upon Article 50 to form a permanent arrangement which is not envisaged for, is not a realistic one. Therefore he advises we accept it.
As I say, I'm grateful to my honourable friend for his question. As I've said, I think there is unquestionably a risk. There is a legal risk because there is no unilateral means out of the backstop. The question is, with what degree of probability does one think it would arise? My view is that it is not probable, but other members will have their own views.
Can I gently remind colleagues of the need for brevity? Stephen Kinnock.
Thank you, Mr. Speaker. The Attorney-General may be familiar with the terms of the so-called Norway Plus option, in which the United Kingdom would join the European Economic Area via the EFTA pillar and would combine that with a customs union. Can he confirm that that arrangement would supersede the backstop, and in that case the backstop would in fact fall away? Can he also confirm that it is possible to unilaterally come out of the European Economic Area via Article 127 of the EEA agreement, so it enables a unilateral withdrawal?
If an EFTA-style arrangement, because of course you cannot belong to EFTA if you are a member of a customs union, with a customs union were introduced, I can see no reason why it wouldn't satisfy the stated objectives of the backstop in protecting the hard border and north-south cooperation. He asked me, is it terminable? Well, of course, the EFTA arrangement is terminable. It's terminable on, I think, 12 months' notice, but I may be wrong. However, a customs union would fall to be negotiated specifically with the European Union, and one would have to examine, one would have to insist upon such a termination clause in that union. That would be a question of agreeing it with the union.
Andrew Bridgen.
With Dr. Carl Boudenbacher, the recently retired president of the EFTA Court, and I quote, "This is not a real arbitration tribunal. Behind it is the European Court of Justice. It decides everything. This is taken from the Ukraine agreement," and he goes on, "It's absolutely unbelievable that a country like the UK, which is the first country to accept independent courts, would subject itself to this."
Well, I don't accept that characterisation, because in any event, the only things that can be brought before the tribunal are systemic operational issues to do with the management of the agreement by both sides. The court cannot get involved once the winding down has taken place in the resolution of individual disputes between citizens and businesses of this country. And members really must understand that. It will be over. The ECJ's jurisdiction will be finished once the winding down takes place. This is an entirely different situation to resolve disputes between the state of the United Kingdom and the European Union. And where we have agreed to apply European Union law, it makes perfect sense that the EU court should interpret it, and then it should be applied by the arbitral tribunal. I see no real fundamental objection to it, I have to say, to the honourable friend.
Iain Murray.
Speaker, there is another strong constitutional principle in this House, that if a motion is brought before this House that the Government disagrees with, it uses its majority to vote it down. In this case, they did not. It is not in the national interest, it's in the Government's interest not to produce this legal advice. So can he tell the House what legal advice he'll give the Cabinet, the Government, or indeed himself, on the principle of not abiding by the will of this House?
It is not a matter, I must ask the honourable member to accept, it is not a matter of the government's interest. It is a matter of the public interest of this country in a fundamental convention and principle. So that's what I understood the honourable member to ask. So with respect, I simply can't accept that this is being done to protect the government. It isn't. It's being done for one reason only, the public interest. And the question for this House will be whether or not the government, which is trying to protect the public interest, or any individual member of the government, is being contemptuous of the House when it is driven, and he is driven to this position by a firm and conscientious conviction that it is contrary to the public interest.
Anne Main.
Much, Mr. Speaker. May I suggest that when he argued with the honourable member for Belfast North that the differences were going to be niggling and almost invisible, that's a bit like suggesting you're a little bit pregnant. This is a sellout in terms of the Union, and at what point is our Prime Minister's pledge that we would not make separate arrangements for any country in the Union going to be sold out in his argument of the national interest?
Well, I don't agree with the honourable friend that it is a sellout. I think that it is, in no question, there are aspects of it that are both undesirable and unsatisfactory. But this backstop need not ever be triggered, and if it is in, I am confident we can emerge out of it. And it will also produce significant benefits for the people of Northern Ireland. Let us not forget that, were it ever to be engaged.
Question. Yes. Chris Williamson.
Many commentators and honourable members believe that the Attorney-General is in contempt of Parliament. If that is indeed the conclusion of Parliament, the penalty for which I understand could include expulsion from this place. Is the Attorney-General prepared to be expelled to stand by his refusal to provide the details of the advice he's given, which has been voted for by this House?
Well, I hope the House will reconsider the position. I hope that it will understand that no attorney would wish to place himself, and no government, but certainly not I as Attorney-General, in contempt of the House. That is simply nothing to my desire or wish. And I would not take this position if I did not feel that it was contrary to all of our interests. And therefore I stand here before you, fully understanding the nature of the House's concern, not to say indignation. I accept that. It is a deeply unsatisfactory position for any attorney or government to be in. And I am truly sorry that I am not in a position to disclose either the fact or the content of my advice. But I am doing so not to frustrate the legitimate interests of the members opposite or members behind me, but rather and only because I do believe it's against the public interest at a time when we're negotiating, and at a time when these involve advice to a cabinet, or might well involve advice to a cabinet, which must be kept, for reasons of fundamental principle, confidential.
I do wish I could encourage members to compete in terms of brevity with the Right Honourable Gentleman Member for New Forest West, who is frankly in a league of his own, untroubled by any close rival. Let that situation change. Mr. Crispin Blunt.
Mr. Speaker. The attorney's made clear that these provisions about the backstop are to address the no hard border, that there would have been no agreement without these backstop provisions being in the agreement. So when we're making our political judgment about the potential permanence or the reasons behind this backstop, what credence should we give to the fact that it is the WTO terms that are
would suggest that there would be a hard border, except under Article 9.3 of the WTO, there is the potential for a waiver, and Article 21, there is a potential for a national security waiver. Given that the EU and the Republic have both said they would not put up a hard border, what conclusion are we to come to about their good faith and best endeavours?
My honourable friend must understand that we can't look at this simply as a question of the traffic of goods between the Republic and Northern Ireland. The stated objectives are to protect in all its dimensions the integration that has taken place between Northern Ireland and the Republic in health treatment, in education, in cultural activities. All of these activities are to be protected. And the government of the United Kingdom has made a solemn and good faith pledge to the Republic of Ireland and to the European Union that it will preserve that integration in the interest of the people of Northern Ireland. What we have to do is find a way of doing it that is consistent with the interests of the Union and of the United Kingdom. The backstop is a temporary solution. We will find another, and it will not have, except by the consent of the Stormont institutions, the same problems that the backstop has.
Iain C. Lucas.
What is his authority for the proposition that the opinion of a single Member of Parliament, however eminent, can override a decision made by the House of Commons?
I think I've made it plain. I am not seeking to suppose that I can override the decision of the House of Commons. The House has at its disposal... Well, hear me out. The House has at its disposal... It's the means by which to enforce its will. It can bring a motion of contempt and seek to have that motion passed and seek to impose, through the committee or whichever way it is appropriately done, to impose a sanction. I fully accept that. I don't set myself up contrary to the House. I simply say that I cannot compromise the public interest. And if I had my personal desire... No, the honourable gentleman is shaking his head. Why would he believe it? Does he think I want to be in this position? Does he really think that if there weren't some fundamental bar of principle for me disclosing anything that I might have given to the government, I wouldn't immediately volunteer it to him and all of the honourable members opposite? I'm only doing it to protect us.
Yes, Daniel Kaczynski.
Thank you very much, Mr. Speaker. I must press the Attorney-General on the answer that he gave to my honourable friend from Shipley on his legal advice as to how much we actually do owe the European Union. How can he expect us to vote for this deal if he cannot give us his legal opinion as to what it is specifically that we still owe them? And is some of this money going on goodwill for a possibility of a maybe trade agreement?
There is a formula in the agreement for the calculation of our obligations, but it depends upon others' contributions. It depends on what particular programmes, whether they spend particular sums of money. So there are a series of variable factors, which is why you can't give a firm and clear and precise figure. Now, if my honourable friend is mentioning what might be due after a no deal, well, that would depend upon a series of arguments which would be untested except in a court.
Chris Bryant.
Oddly, I had more sympathy for the Attorney-General before today than I do now, because he's pushed this House to a situation where he knows perfectly well that the government chose not to oppose the motion. The government accepted the motion. It is the will of the House. And he's pushing us now, in effect, to say, yes, he is in contempt of Parliament, because at some point, even a government has to bow the knee to Parliament, surely.
Suppose, I ask the honourable member just to think, suppose there was advice, and suppose the advice contained, I'm not saying this is a hypothetical situation, but the same principle applies. Suppose it contained information or facts or considerations of the most acute significance for the national interests of this country. But you might lose it. What then? Suppose if one loses, no minister could go ahead and harm the nation merely because a resolution, when the House has not seen the document. In court, there is a mechanism for weighing this, but the House hasn't seen the document. The motion of return was traditionally always confined to public and official documents.
That's right.
That's because this procedure has been reinvented recently. And the truth of the matter is that House has no power to command documents that are not public and official. And that is the constitutional question the House needs to grapple with.
Charlie Elphick.
Thank you, Mr. Speaker. May I congratulate my right honourable learned friend on the passion with which he has made his submissions to this House today. And can I ask him, in the light of his advice, would it be a reasonable position for this House to take to invite the Prime Minister to go back to Brussels and ask for a termination date to the backstop, either by notice or by the passage of time?
That is not, as I know, my honourable friend knows, a legal question. We have reached a deal. The House must take a judgment on this deal. If it had been possible to secure a right of termination, specifically a unilateral right, then it would have been secured. It was not secured because the European Union asked for an absolute guarantee at the Northern Irish border, but have said that it is temporary. That is written into the agreement. It may well be that the word temporary is not enforceable in the sense that this will subsist in the event even that negotiations break down. But it is a clear indication that it cannot subsist forever, and as a matter of European Union law, in my view, it can't.
Kevin Brennan.
Thank you, Mr. Speaker. It wasn't just any motion. As he rightly says, it was a motion for a return to release papers under parliamentary privilege. And there are two reasons why he's wrong. One, he has said that his advice there's nothing to see here in his advice, and yet he's trying to argue that by releasing it he would somehow breach the national and public interest. And secondly, he's wrong because he can, under the Ministerial Code, voluntarily release advice under exceptional circumstances without breaching any national interest or any of his deeply held principles. So why doesn't he follow that logic and do the right thing?
The existence of a very rare number of examples where the attorney's advice has been disclosed does not mean, simply because the power exists, that it ought to be exercised in this case. The fact of the matter is, if there were, in the Goldsmith case, it was 2 years after the event. We are in the middle of a negotiation. No, we haven't. No. The future declaration is to be negotiated, and many of the same arguments will apply.
That's right.
But that's yours ahead. Kemi Badenoff.
Thank you, Mr. Speaker. Further to the comments made earlier by the member for Normanton regarding the customs union, could my right honourable and learned friend confirm that the future declaration guarantees that the UK will have an independent trade policy and consequently that our future relationship will not be in the customs union?
I'm most grateful to my honourable friend for that, because it is an important consideration. There are two things of real significance in the political declaration, certainly real prominence. First, that the European Union has accepted that the final arrangement will involve an independent trade policy. You cannot have an independent trade policy and belong to a conventional customs union. Secondly, it guarantees free movement. You cannot have, or rather not, there will not be free movement. You cannot belong to the single market without subscribing to the four freedoms. Therefore, those set the outer boundaries of any deal that is subsequently to be done.
Ryan Davis.
Speaker, the EU withdrawal bill empowers the Prime Minister to submit Article 50
based upon an advisory referendum. So if that referendum is found to be illegal, based on lying and cheating, surely it follows that the advice from that referendum is flawed, and therefore the Prime Minister should withdraw that article, as would be the case with a general election result, where those findings would require another election.
I hope I heard. Will you forgive me about the honourable member's question, because I couldn't quite hear. Other voices were speaking. But if the question was on the nature of the referendum result and the suggestion that it was procured by some sort of fraud, I don't agree with that. I don't agree with that, and there is, I understand, in any event, a case, I believe, that is pending in court, so it would be wrong of me to make any very substantial further comment on it. But the policy of the government is that this referendum result must be honoured, and that's what will happen.
Thank you, Mr. Speaker. Under the current terms of our EU membership, we do have the right unilaterally to leave under Article 50, and we also have the right to leave the unrelated European Convention on Human Rights. What explanation and assurance can the Attorney give the House as to why, under the proposed arrangements, we don't have those two rights?
Backstop, no deal.
Well, as I've explained already, if we're to have a backstop, a unilateral right of termination would be inconsistent with it. It's a guarantee that in the circumstance where a deal is not, or during the negotiations for a deal, there will be no hard border and there will be the protection of North-South cooperation. So that backstop has to exist or there will be no deal. As to the ECHR, that is already protected by the Belfast Agreement. It's embedded in the Belfast Agreement and would have to be preserved for that reason.
I'm grateful, Mr. Speaker. In the notes in paragraph 42, the Honourable and Learned Gentleman confirms that during an extended implementation period, the UK would not be part of the Common Agricultural Policy. This will, of course, have an effect on Scotland. Can he confirm what legal advice was given with regard to the devolved government coming out of the CAP in an extended period?
The question of the CAP is dealt with by the department, by DEFRA, and there will have been advice given, I have no doubt, by government lawyers to that ministry. I'm afraid I'm not in a position to assist the honourable gentleman with any specific advice on that question at the moment, but I'm happy to write to him about it.
Richard Drax. Thank you, Mr. Speaker. We've heard of the will of the House tonight. What about the will of the people, my right honourable friend? They voted to leave the EU, not half in, not half out, to leave in its entirety. Thank you for his legal advice today, but it's full of ambiguity, as I fear the political interpretation could equally be in the future. This is not going to breed confidence in our nation.
I'm the attorney to insert a question mark, which I think the honourable gentleman might have intended. The Attorney General.
I was puzzled as to what I might be answering. I think I disagree with my honourable friend. We're going to leave on March the 29th. We will leave legally. In order to get back, we would have to apply for accession under Article 49. It's a fundamentally different position we will be in on March the 30th, if we can get there. And we've got to get there, because that will honour the verdict of the British people on the 23rd of June 2016, and the best way of ensuring we do, whatever the unsatisfactory elements which I accept are involved in this deal, is to take the key to the door of the cell and get out on March the 29th. And this deal is the best means of doing it.
Jim Shannon.
Thank you, Mr. Speaker. Attorney General, and your somewhat bombastic responses to the honourable gentleman in the House and honourable ladies in the House, you referred, I suggest, he did not address the issue of the backstop down the RAC. My right honourable friend from North Belfast referred to that. So can you, Attorney General, outline the legal implications of Northern Ireland entering into a customs union with no voice or vote for an indefinite period of time, creating to all intents and purposes a United Ireland without the mechanism of a border poll, a vote as called for within the Belfast Agreement?
The honourable member has put his finger on something that I do regard as being one of the undesirable features of the backstop, which is that there will be rules passed
relating to goods. It's a narrow field of human and public life, the trade in goods, but there will be rules passed to which the people of Northern Ireland will not have right of representation in their passage. That is why I think it's essential it should be temporary, why we must strive to make it so, why the extension of the implementation period is a real option in those circumstances, and why I also believe, for the reasons I've already given, that we can avoid it or avoid it being of any great length.
Mr. Robert Halfon.
Thank you, Mr. Speaker. Will my honourable friend publish, I understand not the whole legal advice, but the legal advice around why we have to give £39 billion to the European Union? And he mentioned that there could possibly be an extension to the transition. Will he set out our legal financial obligations if we do extend the transition period?
Well, there would be financial obligations for extending the implementation of the transition period. Those would have to be negotiated at the time. The Joint Committee would consult over them, and it would reflect a reasonable proportional contribution for the period that we were signing up to it. In relation to any advice connected with the £39 billion, again, he will understand I'm not at liberty to disclose advice the government may have received on that matter. But I can say that there has been very widespread commentary on it and discussion, and I commend to him, for example, the European Union, House of Lords European Union Committee.
Alex Norris.
Mr. Speaker, in attempting to prop up this failing deal, the Prime Minister has reached out to opposition benches and asked for our support. Mr. Speaker, does the Attorney not think it's a bit rich to ask for our support, given that we won't even get the courtesy of having the will of this House complied with?
I've said why. I truly wish that I were not in this position and the government was not in this position. I do believe it. I don't know what the honourable lady is saying. If I didn't believe it, I wouldn't be here now, saying what I'm saying. It's contrary to the public interest. I'd be damaging the public interest if I took this decision. I'm here to answer the questions of members opposite and on my side as frankly and candidly as I can, and nothing that I advise today will be different from any other advice that I may or may not have given.
Maggie through.
Speaker, as someone without any legal background at all, could my right honourable and learned friend reassure me that I've interpreted the lawyer-client relationship correctly, and that it allows for the lawyer to provide impartial and proper legal advice, unencumbered by political consideration, and that this convention holds true on the issue that we're talking about today?
Yes, my honourable friend is absolutely right, and no lawyer would be worth his salt if he allowed his personal views or any use to his client or his political ones to affect his judgment on matters of law.
Paul Sweeney.
Mr. Speaker, the Attorney-General has been vehement in his assertion that the release of this information would be detrimental to the public interest. So it's not a matter of regret for the Attorney-General that his government have not had the basic virtue of consistency in approaching this humble address. And now that contempt proceedings have been initiated with a letter submitted against the government, what is his legal advice to the government going to be?
I'm afraid I can't disclose the latter without committing the very sin that I'm trying to prevent. Does he ask me, do I regret it? Let me be frank. Yes, I do. We should have opposed it. Of course we should. We should have voted against it. All I can say is that if we'd lost on a contested vote, we would be in exactly the same position as we are now.
Alex Chalk.
Speaker, if we found ourselves in the backstop, we might seek to argue that the European Union had not acted in good faith, had not used best endeavours. Who would appoint the body that would adjudicate on that dispute? And how could we be satisfied that we were going to get a fair hearing?
The governance provisions set out between Article 167 and 181 provide for 25 independent arbitrators who are not members of any member state of the European Union or belong to the United Kingdom to be appointed by both sides as a panel from which an arbitral tribunal can be selected. 10 are to be proposed by the United Kingdom, 10 by the European Union, and then 5 chairmen are to be proposed by each. If the parties are unable to agree, when a tribunal is formed, 2 are appointed by the UK, 2 by the EU, and those 4 then choose the chairman. If they're unable to decide on a chairman, the Permanent Court of Arbitration will appoint by lot.
Andy Martin.
Thank you, Mr. Speaker. Can the Attorney-General tell this House whether he conveyed to the Government Chief Whip, directly or indirectly, his determination not to comply with the humble address before the decision was taken not to vote on it?
Yes.
I had no discussions with the Chief Whip about the decisions to vote or not to vote on this matter. I hope that answers the honourable gentleman's question. If there's another part, Mr. Speaker will forgive me, and I've omitted part of the question. I wonder if the honourable member could put it again.
Order. It doesn't help if there's a lot of noise. The attorney is perfectly at liberty to answer as he thinks fit, but when he looks quizzically, and I only say this by way of interpretation, I think the honourable gentleman asked whether the right honourable and learned gentleman had conveyed his views about this matter directly or indirectly before the vote on the motion about which we have been speaking this evening. And he indicated he had not spoken directly, he had not conveyed his views directly, and I think the quizzical attitude is, was there any indirect communication? Thank you. Dr. Caroline Johnson.
Thank you, Mr. Speaker. My current understanding is if there is no deal, we would leave with no backstop on the 29th of March. If the EU and the Republic of Ireland in particular have been content to effectively have a leave without backstop with 2 years' notice period situation until now, what does the Attorney-General think has changed that makes it unacceptable to them now? What does he consider their motivation for that to be? And as an aside, can he confirm that in extremis the Vienna Convention can be used to allow treaties to be broken?
The Attorney-General.
The purpose of the backstop is to give the people of Northern Ireland and the Republic the confidence of knowing that there will not be any retreat from the current integration that has taken place between them over the last 20 years. That is a solemn commitment which it is in the interests of Northern Ireland as well as the Republic of Ireland should be done. The question is how you achieve it. Now, in the interim, before another solution is found, which I firmly believe we shall, this is the solution that would pertain were we ever to have to use it. As to the Vienna Convention, there is no provision in the Vienna Convention that allows us to terminate a treaty that has no termination clause and that is plainly intended to subsist until another event takes place.
Jim McGovern.
Thank you, Mr. Speaker. I had hoped today that we would have clarity of thought and calmness of expression so that we are all informed on the matter which we are due to vote next week. I can say we haven't had that. We've had bluster, we've had posturing, and we've had very clear contradictions, because on one hand we're told there's nothing to see here, and then on the other it would be against the public interest to release information. So my question is this: if the House hasn't got confidence in the Attorney-General to deliver this advice in the way that we think is needed, is there any route in the Constitution via the Leader or elsewhere for us to get alternative, independent legal advice straight to this Parliament?
I'm very sorry that the honourable member feels that. If I have expressed myself intemperately, it's simply because of the questions that I've been asked and trying to convey, obviously unsuccessfully, the fact that I am only here to justify or to seek to defend this position because I believe in the public interest. And that's the reason why I am saying what I'm saying. And, but on all points of law that I have been asked, I have given him my best judgment, my fullest judgment, and my starkest judgment about what the situation truly is, as I would give to anybody, including the government. And I assure him that is the case. That is complete and full truth. I have given absolutely candidly the legal views that I hold on this matter.
Robert Court.
Thank you. Thank you, Mr. Speaker. I'm very grateful for the Attorney's indication that Article 50 does not provide a legal basis in union law for permanent future arrangements. Could he give his view on the concern that it might nonetheless proved to be a basis for arrangements that proved to be indefinite?
No, I don't believe that. I don't believe that is the case. Once it became de facto the subsisting and permanent arrangement in that there was no prospect of agreement because negotiations had broken down, then it would be severely vulnerable to challenge, because it's widely understood that Article 50 cannot be a proper basis for any sort of permanent or enduring arrangement. And the fact of the matter is that it would be extremely vulnerable to legal challenge.
Thank you. Order. I will come to the honourable lady in due course. A point of order, Mr. Nick Thomas-Symonds.
Thank you. Thank you, Mr. Speaker. On a point of order, I seek your guidance regarding how the House should proceed in pursuing the publication of the advice provided by the Attorney-General to the Cabinet. It is clear to us on this side of the House, and we believe the overwhelming majority of the House, the document provided does not constitute the final and full advice provided by the Attorney-General to the Cabinet. More importantly, this does not comply with the motion of the House that you, Mr. Speaker, have ruled to be effective. And indeed, Mr. Speaker, I'd suggest in the course of his statement, the Attorney-General has been quite open about the fact that he isn't complying with the motion on his belief it isn't in the national interest to do so. Now, my right honourable friend, the Shadow Brexit Secretary, along with the SNP's Foreign Affairs and Europe spokesperson, the Liberal Democrat spokesperson on Brexit, the Deputy Leader of the Democratic Unionist Party, the Plaid Cymru spokesperson on Brexit, the Leader of the Green Party in Parliament have this afternoon written to you, Mr. Speaker, asking whether you would consider giving this House the opportunity to debate and resolve whether this is a matter of contempt at the earliest opportunity. It is clear to me, Mr. Speaker, that the Government has taken an unprecedented decision not to comply with the unanimous and binding decision of this House. Instead, Mr. Speaker, they seem to be playing for time, hoping that contempt proceedings take longer than the timetable for the meaningful vote, and we as a House cannot allow this to happen. I therefore ask you, Mr. Speaker, to set out how we should proceed to resolve this vitally important matter.
Well, I'm grateful to the honourable gentleman for his point of order and for his characteristic courtesy in giving me advance notice of his intention to raise it. I shall ignore the sedentary chuntering which is undertaken for no obvious benefit or purpose. I have only just seen the letter to which the honourable gentleman refers. I shall give it immediate attention when I leave the chair, and having sat through these exchanges, I intend to come to a rapid decision which I will convey to the House before it rises tonight, or, if that proves impossible, at the earliest opportunity tomorrow. I hope that that is helpful to colleagues. The Attorney-General, on a point.
I say that, as I indicated during the course of the debate, I had concluded, I think mentioned as well, that I will be writing to you this evening, setting out the government's proposals in connection with this matter. I wonder if I could invite you to consider that letter, as I'm sure you will, in due course this evening.
Well, I await... Order. I note what the Attorney-General has said, and of course I shall be interested to see any letter that he chooses to send to me. It is important that this matter is dealt with in a timely fashion, and that is order. That is a highly relevant consideration for me to take into account. But I have heard, with respect, what the right honourable and learned gentleman has said, and I wait to see what emerges. Point of order, I will come to the honourable lady. Point of order from the Chair of the Justice Select Committee. Point of order, Mr Bob Neal.
Thank you very much, Mr Speaker. The letter that has been referred to by the honourable member for Torfaen does touch upon a most grave matter on any view to all members of the House. Is it either within order or courteous that the text of that letter should have been released to a journalist who has then put it up on Twitter? I know it agrees with the journalist, but was it in order for honourable members or those acting on their behalf to release it before you were apparently aware of it or had a chance to consider and rule upon it?
Well, it's always best if letters sent to me are received and seen by me before they're seen by others, but I will address the substantive responsibility which is vested in me. That is, frankly, a different matter and, on the whole, a rather more important matter. But I always treat the honourable gentleman and all members with courtesy, and I note what he said, and I have issued my response in the first sentence of my reply to him. Point of order, Anne Main.
Thank you very much, Mr. Speaker. And as usual, you called every member of the House that wished to ask questions. But the convention of the House is that we have no rebuttal or right of coming back on any questions asked. Given that the attorney said he was happily going to answer any questions, for someone with no legal background, I feel I've having to play guess the question of what we may need to know that we haven't been able to ask. Would it be in order that the House manages to table a series of questions that are answered, anything they would like to have put to the Attorney-General but didn't get the opportunity to do so, and that those are answered as quickly as possible to give us more information than we could glean today?
Let me say in all courtesy, I'm not sure, given the pressure of time, of the practicality of the arrangement that the Honourable Lady is advocating. Let me, for the avoidance of doubt, however, say to the Honourable Lady that I have no reason to doubt either her legitimately insatiable appetite for interrogation, a very proper appetite in a committed parliamentarian, which the Honourable Lady is, or indeed that of the Attorney-General for responding to questions. Therefore, in an ideal world, I would be quite open to the idea that there could be further questioning. As the House will know, I'm an unusual fellow. I enjoy few things more than listening to my colleagues asking questions and ministers answering them, which is probably quite useful, really, given that that is what the Speaker of the House is expected to do. But I do think we have come up against the matter of practicality. And although the Honourable Lady may now have her head filled with questions that she wished she had asked, but has not done so, we do have to progress and expedite matters. So I hope that she'll feel pleased that she has at least asked a question and she can make her own assessment as to the quality of the answer. If separately she wishes to beetle up to her right honourable and learned friend and put a question to him, I feel sure that she'll be greeted by the courtesy that the attorney invariably displays. Will it go very well? Point of order, Mr. Jim McMahon.
Thank you, Mr. Speaker. We've all had sight of the copy cross-party that's been sent to you, Mr. Speaker. In light of the letter that's due to follow from the Attorney-General to you, will we also have a copy of that letter as well?
I feel sure that that will be so, and the attorney is nodding in his assent to that proposition. In other words, just to be clear, I think that the honourable gentleman is asking, can he have sight of the attorney's letter, and I think the attorney is signalling that the answer to that is yes. Oh, very well. Yes, completely different, I feel sure. Point of order, Mr. Chris Bryant.
Because you're a cerebral fellow, Mr. Speaker, you will know that on the 30th of October I asked the Foreign Secretary why it was that the Magnitsky clauses of the Sanctions and Anti-Money Laundering Bill had not yet been implemented. And he said in the Chamber that this was because we're members of the European Union and we can't implement sanctions of our own till we've left. He repeated this the next day in the Foreign Affairs Committee, but a week later, the Permanent Under-Secretary at the Foreign Office said, no, it's nothing to do with that, it's because we haven't got any time to draft the statutory instruments. Now, the Prime Minister today returns to the original advice provided by the Foreign Secretary. The legal advice that has been provided to the committee by the clerks of the House is that actually there's no reason why we can't introduce our own sanctions, because we did so back in 2011. I just wonder where I will be able to get definitive legal advice from, and whether you think that, considering that the Foreign Secretary said on the 30th of October that he would write to me, that now is sufficient time to have passed for me to have had a reply.
Yes, I mean, what I would say to the honourable gentleman is the following. First of all, I recall his inquiry of that date. I wouldn't have been able to pinpoint that date. I advise those attending to our proceedings out with the chamber. I don't have that level of Anarakish recall of the parliamentary contributions of the honourable gentleman, but I do recall the fact of that question being put. It made an impression on me, as so much of what the honourable gentleman does makes an impression on me. Secondly, I would say that as a matter of principle, the Foreign Secretary ought to have replied to a letter of that date, if it was of that date, from the honourable gentleman by now. And thirdly, as a matter of practicality, I say it is somewhat unwise for a minister, in this case apparently the Foreign Secretary, an extremely experienced and dexterous as well as courteous parliamentarian, not to have replied to the honourable gentleman by now. For to fail to provide a reply was to be bound to invite excoriation. And the Foreign Secretary is now going to be on the receiving end of that as soon as he learns of the honourable gentleman's point of order. So I hope that on all three counts I have brought some happiness into the life of the honourable gentleman. Oh, very well. I'll come to the front bench. We must try to bring matters to a close shortly, but yes, I will come to the honourable lady. But point of order, the honourable gentleman, right honourable gentleman from Brent North.
Mr. Speaker, I would like to raise a point of order regarding a response I received from the Minister of State for Energy and Clean Growth at the last Bay's oral questions. I asked the Minister why a roundtable with all the key fracking companies, which she held on the 21st of May, had not been declared in the Transparency Register. In her response, the Minister claimed that her officials did not disclose the meeting of the 21st May because the Ministerial Code does not require ministers to disclose meetings they drop in on as opposed to host in their office. I've searched the Ministerial Code and can find no reference to a difference in disclosure requirements, such as the Minister suggests. It would also appear that the Minister's involvement in the meeting may not have been as casual as she suggested. During a Westminster Hall debate on 10th of July, the Minister in fact claimed, "I did hold a very effective shale industry roundtable." An FOI request querying the nature of that received a letter in response where the Department stated that this was indeed the shale roundtable that the Minister of State hosted on the 21st May 2018. By the Department's own admission, this was a meeting the Minister had hosted rather than dropped in on. The agenda of the meeting was also released under the FOI. It reveals the extent to which the Minister was present. The roundtable began at 1 o'clock, finished at 2 o'clock 35 p.m, lasting 95 minutes. The Minister was present for at least 70 minutes of the 95, 7-0. This would not, by any reasonable opinion, I contend, constitute dropping in on the meeting. I would seek your advice, Mr. Speaker, as to whether any request has come from the Minister seeking an opportunity to come to the House and correct the record.
I'm grateful to the honourable gentleman for his point of order. The short answer is that no request has been made by the Minister concerned or by any other Minister to make a statement of correction or other statement, as far as I'm aware, on this matter. If a Minister believes that he or she has erred, it is not only open to that Minister to correct the record, it is incumbent upon him or her to do so. I have received no such indication. The honourable gentleman is a versatile and experienced parliamentarian, and he can pursue this matter further if he so wishes, in a variety of ways, whether in correspondence or through questions, but not further tonight by this mechanism. A point of order, Mrs. Helen Goodman.
Thank you, Mr. Speaker. Further to the point of order raised by my honourable friend, the member for the Rhondda, I today received a letter from the Minister of State in the Foreign Office about the fact that the statutory instruments will shortly be before the House. So I'm sure if my honourable friend wishes to, he will be able to be on the committee when we examine these, and we will all benefit from his wisdom on this matter.
Well, that's extremely interesting information, and I'm very grateful to the honourable lady, and I feel sure that she feels that she has done the House a signal service. Oh, very well. Very briefly, I fear the honourable gentleman will tax the patience of the House. Point of order.
In which case, the Prime Minister this afternoon inadvertently misled the House, and she must have an opportunity to apologise and correct the record.
Well, If anybody has inadvertently misled the House, that person must correct the record. I hope that the honourable gentleman will accept if I do not think it incumbent upon me now to act as arbiter of whether that has or has not happened. The issue has been given a full airing. Both members are very experienced and are not backwards in coming forwards and can pursue this matter either through the use of the order paper or by other means in the days ahead. And I don't in any sense seek to deny them the opportunity to do so.